Good afternoon, everyone. We'd like to call the Friday, July 17th, 2026 meeting of the Livingston County Electoral Board to order. Please speak into the microphone. State your name prior to speaking, and only one person at a time speak, please. At the July 10th, 2026 Electoral Board meeting, Circuit Clerk Jacqueline Gregson excused herself from the board, leaving a vacancy. Judge Costigan appointed Leanne Dixon, former Circuit Court Clerk, to serve in her place. We'll now have our roll call vote. Treasurer Mary Nikki Meyer.
Here.
Leanne Dixon, former Circuit Court Clerk.
Here.
And County Clerk Christy Ann Mashing. Here. We have a quorum and we'll proceed with the meeting. Also present and assisting the board is Stephen D. Mart, attorney with the Ansel Glink Law Firm. Sandra Sammy Reinders is the court reporter. Now we'll move on to the approval of the agenda. Is there a motion to approve the agenda?
I'll motion to approve the agenda.
Is there a second?
I second the motion.
The motion to approve the agenda has a second. Those in favor respond with ayes. Aye. The agenda is approved. Is there a motion to approve the July 10th, 2026 meeting minutes?
I'll make a motion to approve the July 10, 2026 meeting minutes.
Is there a second?
I second the motion.
The motion to approve has a second. Those in favor respond with ayes.
Aye.
The agenda is approved. I will call the case before us. Petitioner's objection to the respondent's petition to be on the November 2026 general election ballot as a Republican candidate for the position of State's Attorney of Livingston County, Illinois. Michael Donald Stalter, petitioner, objector, versus Mary Lawson, respondent, candidate. An appearance as counsel was filed by Robert P. Fulmer for petitioner, objector, Michael Donald Stalter. An appearance as counsel was also filed by Mary Lawson, representing herself as respondent candidate. We'll move on now to the procedural matters for pre-hearing motions. There were two preliminary or pre-hearing motions filed. The first one was Mary Lawson. She filed a respondent's motion to strike and dismiss petitioner's objection pursuant to 735 ILCS 5/2-615 and the Electoral Board Rules of Procedure on July 13th. Bob Fulmer filed the petitioner's response to respondent's motion to strike and dismiss on July 16th. At this point, we'll have the arguments on the pre-hearing motions, and I will turn this over to Attorney Mark.
All right. Ms. Lawson, do you want to argue your motion?
Yes. Does the board want us to argue from our tables or from the podium?
Whatever you feel comfortable with.
I'm not going to recite my whole motion to the board. I know that you guys have reviewed that in preparation for today. What I think is important to recognize is the timeline in regards to this open position of the state's attorney. This position was previously held by Mr. Michael Regner. He was appointed by the county board following a vacancy of what is now Judge Randy Yednock. That appointment took place on March 1st of 2023 and was effective through November 30th of 2024. He then had to run an election to continue in that position. In that manner, he was on the primary election, or excuse me, the primary ballot in March of 2024, and then ultimately on the general ballot in November of 2024. He won that election in November of 2024, taking office beginning December 1st of 2024. That went through or was good through November 30th of 2028. I think that timeline is important for this board to understand because the petitioner's objection and even their response to my motion focuses on the primary of 2026, indicating that there was not a nominee or a candidate in that primary. But there wouldn't have been because that position, this being the state's attorney position, did not appear on the primary for March of 2026, as the term is good through November of 2028. And as of March of 2026, Mr. Regner was still filling that position. He had not yet resigned. That resignation did not take place until May of 2026. Therefore, there was no position to be on the March primary ballot, and therefore no candidate or nominee necessary for that. So when you look at the petitioner's objection and even their response to the motion, they focus on this idea that there was no nominee. And because there was no nominee, they are focusing on a different statute. But that statute does not apply because there was not a nominee, because it was not on the ballot. There would not have been one. The appropriate statute for this this board to consider then is the one that I cited in my motion, that being 10 ILCS 5/25-11. This statute addresses when there is a position that has an elected official sitting in that position who then resigns or vacates that position after the deadline for the primary, but before the end of their elected term. That is what we have before us here. Mr. Regner resigned or vacated his position after the deadline for the March 2026 primary, before the ending of his term in November of 2028. The statute that I have cited for this board to consider then is the appropriate one. In regards to the argument that the petitioner makes that there was not a nominee, I think that argument is completely ignoring the timeline that is important for this board to consider. The statute that they have cited and asked this board to consider addresses the fact when there is a vacancy on a ballot, meaning that it should have been on the ballot, state's attorney position should have been on the March 2026 ballot, but there was a vacancy, there was no Republican candidate. And after that, then the Republican Central Committee would have this opportunity and laid out exactly how the petitioner has laid that out, but it ignores the fact that that position was never there to begin with. And so I think that when you look at the timeline and you understand the timeline and the appropriate statutes that apply, the petitioner's objection should be stricken or dismissed. Thank you.
Mr. Fomer?
Yes. Thank you. The thing that's got to be considered here is the difference between a vacancy on a general ballot, election ballot in November, where there never was a nominee after a primary, or where at some time after the primary, regardless of how it happened, there is a vacancy in a local public office, elective office, which needs to then go on the general ballot in November. When you look at the whole thing, except for 25-1 and how it purports to use 7-11.1 for a political party to get a nominee on the ballot, it always talks about if there never was a nominee, then whatever was filed, resolution or a nominee, always had to be accompanied by the requisite signatures on a petition, because it had to demonstrate when there was no nominee at all to begin with. It has to demonstrate some modicum of support for that person. So even if the party replaces or adds a nominee, it's really not replacing, it's adding one, they still have to attach the requisite number of signatures with the nominating petition. And so I think that's important to understand the overall thought process in the legislature when they created this whole scheme. if there was already a nominee for a local party, then that party can go ahead and nominate somebody else to be on there within the timeline without having to go out and gather a bunch of signatures because they've already shown support for that office and that party. We don't have that situation here. The Office of State's Attorney became open when Mr. Rigner resigned. That was on May 15th, but let's just, for purposes here, we got to take a look at what would have happened if he had not resigned until May 27. Under the candidate's theory, no independent candidate could get on the ballot at all. And yet, an established party could put somebody on the ballot. And that's almost pretty much certain that would be unconstitutional if it was applied that way, because the legislature can give different time limits for established parties versus new parties versus independent candidates, but it can't be too desperate. I mean, it can't be too far apart. This one here, we go from, for instance, on May 27, if that's how you were to interpret 711-1.1 the way the candidate wants you to interpret it, you'd have a situation where parties have 3 months to get somebody on there and nobody else can get on. That would certainly be ruled unconstitutional. Now, this board can't rule on the constitutionality or unconstitutionality of any process or procedure, but I think that's something you can keep in the back of your mind when you're trying to decide how are we going to interpret what the legislature said the requirements were to get on by the, in this case, August 26th, by the local party. I don't know what the legislature was doing. They messed up big time in this case here. They purported to carve out a situation where there's a vacancy in the office, which is filled by appointment by the county board, but then if there's more than 28 months left, then you got to put it on a general ballot. And they tried to carve that out, but they only gave established parties any kind of an opportunity to get on the ballot, which isn't, I think it's unconstitutional. I don't think you can presume they meant to do that. Also, they set up something through 711.1, which is impossible to satisfy. The statute says quite clearly, any resolution submitted by the local established political party shall state where'd it go? The name of the original nominee and the office vacated. There is no original nominee. That can't be satisfied. If you even look at the resolution that was filed, I don't know, maybe I missed it. I don't see anywhere on there where they cite 7-11.1 for their authority for filing this. It says 7-61, which is the statute we cited for why it fails to meet the timeline of June 1st. This electoral board cannot try to guess or come up with a theory or conjecture as to what the legislature meant to do. You can only read the plain meaning of the statute, and the plain meaning of the statute cannot be interpreted to allow a resolution in this case, because again, they can't satisfy the very first requirement, which was the name of the original nominee. It can't be done. I don't know why the legislature did it that way. It is possible, I suppose, that a court, if this case ever goes through, could possibly rule that, well, based upon the overall scheme and everything else, the legislature made a mistake, but it's not fatal because we can interpret it to say this, this, or that. The court has that authority. This board does not. You're stuck with what the plain meaning of the words are. And if they can't satisfy, they've set up a situation where it cannot be satisfied. And so this nominating resolution should not be allowed. It should be determined to be invalid. If you can't file it under a 711.1, then you have to fall back to 671, and that date there clearly is June 1st. And again, just as to show how confused I think the legislature was when they did this, this is a case where there was not a nominee in the first place. And in all the other instances where there's not a nominee in the first place, there's got to, the resolution or the application has to be accompanied by the requisite number of signatures of voters in the county. It wasn't done here. So this board's going to have to speculate, read language into it, or disregard language that is in it in order to allow this petition to be filed and accepted. And we would ask that the motion dismiss or strike be denied, and that the resolution be determined to be invalid. And this will be a situation where no one's on a ballot, it sounds like, which is fine. There'll still be a race. People can run as write-ins. There's plenty of time for a write-in to get on there. It's not that difficult to do, and maybe that would be better for all concerned. Thank you.
Before you vote, let me just make a short comment. Mr. Fulmer is correct that it is difficult to read the statutes. I don't know if it was a mistake by the legislature or inartfully drafted terminology, or if they intended it the way they did. But the board is bound to make a decision, and it has an issue squarely before it, and the board will make its decision. And I assume that it will be appealed to a higher authority, to the judiciary, and perhaps the judiciary in its wisdom can reconcile these two statutes in some way that the board found difficult to do, but the board is making a decision, and the case will proceed from there.
Okay, I will go ahead and I'll make the motion to adopt the electoral board findings and decision and grant the motion to strike the objection. Do I have a second for that? We'll do a roll call. Okay. I will repeat the motion. I, Christy Mashing, make the motion to adopt the electoral board findings and decision and grant the motion to strike the objection. Okay, roll call. Nikki?
Yes.
Leanne?
Yes.
Christy? Yes. All those in favor?
Aye.
The motion passes. Is there anything else?
For the record, the board will sign the findings and decision and hand written or executed findings and decisions to the parties. now, so that, yeah, so that you will have the findings and decision in your hand.
I'd just like to ask a question for future reference. What's the point in us getting up and arguing the case when the decision had already been made? You've already got findings and a decision written up, and why did we get up and argue it then? Just curious.
I guess because there's a lot to each of it. Both of you explained different ways, and when we had done, were notified that there was going to be.
Well, just let me jump in here. I think hearing the arguments clarified the issues, and it also put your positions on record for review by a court if this matter proceeds to court. So I think that's helpful. And the board was able to hear the arguments, and the arguments that you made were considered by the board.
Well, the oral argument today wasn't considered. The decision's already been made.
No, the argument was considered, and you'll find in the findings and decision.
Okay.
that-
But I mean, nothing that was said today was considered.
Well, it is on the record.
Okay.
All right, is there anything else either party would like to say? Okay. Motion to adjourn?
I'll motion to adjourn.
Second?
I'll second that motion.
Motion carried by voice vote. Meeting adjourned at 3:30.